Subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone to today's hearing on legislative reforms to end lawfare. I will now recognize myself for an opening statement. Welcome. We are here today to discuss potential legislative reforms to end lawfare by state and local prosecutors. Rather than debate political opponents on substance, my colleagues on the other side of the aisle thought they could win the 2024 election through the use of partisan lawfare tactics. Lawfare has been defined as, quote, the strategic use of legal proceedings to intimidate or hinder an opponent, end quote. Lawfare violates the fundamental mission of prosecutors. Prosecutors' job is to do justice. As a former assistant United States attorney, I made it my duty to uphold the law with fairness on those I charged, making sure their civil liberties were kept intact. Additionally, when I was a prosecutor, I methodically ensured the cases that were brought before me would not fall to political pressure or succumb to outside influence, especially to score cheap political points. Every American deserves to have a justice system that is divorced from the political whims of elected office holders, political parties, and personal vendettas. In their political pursuit of President Trump, however, we saw state and local prosecutors abuse professional norms in favor of achieving indictments against their target. Prior to the 2024 election, President Trump was criminally indicted 4 times. Let's take a quick look at the state and local lawsuits brought against President Trump. First up, Fulton County, Georgia District Attorney Fani Willis's 41-count indictment against 19 defendants, which included President Trump, his attorneys, his former White House Chief of Staff, and a former Justice Department official. The politicized nature of this prosecution is hard to ignore. A mere 4 days before the indictment, DA Willis launched a campaign fundraising website highlighting her investigation into President Trump. And though DA Willis's investigation was first reported in February of 2021, it was not until President Trump announced his candidacy that she brought charges. And later, DA Willis requested that the trial begin on March 4th, 2024, the day before Super Tuesday and just 8 days before the Georgia presidential primary. To charge President Trump and his co-defendants, DA Willis used a broad interpretation of Georgia's RICO law, which is intended to be used to prosecute criminal enterprises that infiltrate legitimate businesses and use interstate commerce. For background, RICO statutes are used to prosecute organized crime mob bosses, street gang leaders, and other crime syndicate heads, not typically elected office holders on absurd charges. Prior to indicting President Trump, she coordinated with special counsel Jack Smith and the partisan January 6th committee. Her lead prosecutor, Nathan Wade, met with the Biden-Harris White House on multiple occasions. Then we have New York Attorney General Letitia James, who has made her disdain for President Trump well known. When she ran for New York Attorney General, she made many personal attacks against President Trump, calling him things like con man, carnival barker, and even an illegitimate president. As soon as she took office, AG James began investigating President Trump. In September 2022, she sued the president, alleging that he and his company had committed fraud to inflate the value of his properties. Now let's turn to Manhattan District Attorney Alvin Bragg, who indicted President Trump with 34 counts of falsifying business records, which was tied to an unknown federal crime which aggravated the charges to felonies. The Manhattan District Attorney's Office had been investigating President Trump since 2018. But it wasn't until after President Trump announced he was running for president in late 2022 that Bragg elected to resurrect the zombie case against President Trump. And who did he bring on to help his politicized investigation? Bragg hired senior Biden-Harris Justice Department official Michael Colangelo to jumpstart his office's investigation of President Trump, reportedly due to Colangelo's, quote, history of taking on Donald J. Trump and his family business, end quote, while working for the New York Attorney General's office. One should be equally concerned if it were a Republican district attorney engaging in this conduct toward a former Democrat president, cabinet secretary, or White House official. These prosecutions are precisely what former Attorney General Robert Jackson warned us about. Attorney General Jackson warned about the most dangerous power of the prosecutor, quote, that he will pick people that he thinks he should get rather than pick cases that need to be prosecuted. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself, end quote. And that is precisely what we have here. This is why Congress must address Democrats' lawfare efforts by popularly elected state and local prosecutors against federal officials. In fact, many of my Democratic colleagues on this committee are vocal proponents of a fairer criminal justice system, calling an end to perceived needless instances of overzealous prosecution, wrongful arrest, and detention, and limiting incarceration overall. What better way to achieve these goals than engaging in this hearing to uncover possible missteps by state and local justice systems and ushering legislation to rectify these glaring blind spots? Current law does not adequately protect federal officials from rogue state and local attorneys who stack unwarranted charges against their political opponents. Under current law, the option to remove civil or criminal cases from a state court to a federal court is limited to federal agency officials and legislative and judicial officers. Our colleague on the Judiciary Committee, Congressman Fry, has a bill that would fix this problem. The Promptly Ending Political Prosecutions and Executive Retaliation Act of 2025 is designed to protect our nation's leaders from lawfare tactics. This bill gives both current and former presidents of either party, vice presidents, and federal officials the ability to remove civil and criminal cases against them from a state court to a federal district court. The bill also codifies the immunity recognized by the U.S. Supreme Court for official acts carried out by a federal official. This bill should not be misconstrued as a get-out-of-jail-free card. Far from it. It should be an opportunity for individuals to have a shot of non-politicized due process experience. Make no mistake, if a federal official were to commit theft, fraud, assault, or other crime, they should be held accountable regardless of political party or policy views. This introduced bill should be welcomed by both parties, as no individual acting within their duties should be sought after because of whom they work for or their political leanings. I'm looking forward to discussing that particular bill, as well as the need for legislative fixes in this space today. I want to thank all of our witnesses for being here today. We look forward to your testimony and the robust conversation on how we can move forward and fix this problem. I now recognize the ranking member, Ms. Scanlon, for her opening statement.
Thank you. I would like to welcome our witnesses here to the Subcommittee on the Constitution, but it's a little hard to do so when this committee, and apparently the entire House majority, seems to have lost their way and forgotten the basic terms of that Constitution. Instead of acting as a co-equal branch of government as designed by our founding document, this House majority is content to abdicate Congress's authority to make and fund laws to a would-be dictator and his billionaire tech bro. Speaker Johnson and House Republicans have gone along with White House efforts to gut basic services that Americans rely upon, whether at the VA, Social Security Administration, or the National Institute of Health. And they've teed up huge cuts to Medicaid, SNAP, and more, all so they can give more tax breaks to their billionaire buddies that will explode our national debt. Instead of lowering costs for American families, they've encouraged the president's tariff wars that are already driving up inflation and tanking the stock market. The bills our House Republican colleagues are filing and bringing to the floor are an embarrassment. They're seemingly engaged in a contest of who can debase and subjugate themselves to the president the most, with measures like adding Trump's face to Mount Rushmore, designating his birthday as a national holiday, and printing $250 bills with his portrait on them. Which brings us to the bill that forms the basis for today's hearing. It's another attempt to refashion the rule of law to flatter a narcissist and felon-in-chief. We know that because it was first introduced last term to benefit one man and one man only, Donald Trump, as he faced 34 felony convictions in New York, a criminal case in Georgia, and hundreds of millions of dollars in civil judgments, all in state courts. This legislation appears to be an unconstitutional power grab by the federal government and a direct infringement on state sovereignty that would upend the framers' carefully calibrated balance of power between what are supposed to be two equal sovereigns. In their shameless quest to help Donald Trump and his cronies evade justice in our state courts, Republicans would have Congress exceed the scope of its authority and grant federal jurisdiction over a host of state court cases. For all their talk about federalism, it begs the question, is there any fundamental principle that House Republicans are not willing to abandon in servitude to this president? The bill before us, the so-called Promptly Ending Political Prosecutions and Executive Retaliation Act, amends 28 U.S. Code Section 1442, the Federal Officer Removal Statute, and other provisions related to the removal of cases from state to federal court. Under Section 1442, a federal officer can remove a state criminal or civil matter to federal court if the case relates to acts taken, quote, under control of the office, end quote, meaning that the federal officer was acting within the scope of his or her official duties. And as a statutory and constitutional matter, the party seeking removal bears the burden of showing that a case falls within the federal court's jurisdiction. Under the Supreme Court's decision in Mesa versus California, removal is not permissible absent a colorable federal defense. The federal officer removal statute is intended to prevent federal officers from being improperly punished for carrying out their duties. It's not a license for them to go around doing whatever they want with no accountability. While I'll leave the point-to-point analysis of this bill to our expert witness, Professor Elizabeth Beski, I will highlight that this bill is troubling for a few reasons. First, it would allow any former federal official to remove state cases for acts taken under color of office. More concerningly, the bill would allow a sitting or former president or vice president to remove cases for or relating to any act while in office, even ones that involve their personal private conduct unrelated to their official duties. It seeks to provide immunity for the president, vice president, and political officers under a misguided understanding of the Supremacy Clause and effectively flips the normal presumption against removal to a presumption in favor of it. In other words, this bill goes a long way towards enshrining in American statute the idea that we're ruled by a king who's above the law. Overall, this bill is unjustified, unworkable, and misguided, especially for the time we find ourselves in. But rather than admit that the legislation they've proposed is blatantly unconstitutional, our Republican colleagues have tried to characterize it as a response to politicized law enforcement leveled at Mr. Trump and his allies. In fact, the chair just tried to describe the bill under consideration as an effort to ensure that all Americans enjoy a justice system free of politicization. But as so often the case, Republican accusations are frequently confessions. If our Republican colleagues want to talk about politicized law enforcement, let's have at it. Because we don't have to go any further than right here in our nation's capital to find the most egregious examples, and in just the past 6 weeks. Donald Trump's Department of Justice has fired hundreds of career prosecutors and FBI agents for doing their jobs without fear or favor. He's targeted those who helped investigate and prosecute the people who violently attacked the Capitol on January 6th, while also pardoning 1,500 of his MAGA followers who rioted and injured hundreds of law enforcement officers that day. In doing so, he put his presidential seal of approval on political violence, so long as it supports him. His Department of Justice has made corrupt quid pro quo deals, dropping federal corruption charges against Eric Adams in exchange for the mayor's agreement to his political agenda. In just his first 44 days in office, Donald Trump's made his cynical vision of government clear. He's wasted no time using the power of the presidency to silence the people whose job it is to hold him and his billionaire buddies accountable. By firing at least 17 inspectors general, making it harder for the truth about fraud and abuse in our government to be exposed, and effectively ending investigations into fraud and abuse by, you guessed it, Elon Musk and members of the Trump White House. He's moved to take control of independent agencies designed to hold the powerful accountable, like the FEC, CFPB, and SEC, and using the FCC to go after broadcasters that produce content that the president doesn't like. This president has undermined the power of the people and this Congress, something everyone in this room should be outraged by refusing to faithfully execute the laws that this body has passed and the money that we've appropriated, and is attempting to unilaterally dismantle programs and entire agencies that Congress created and only Congress can eliminate. This is all happening every day out in the open. But condemning these blatant abuses of power is not the conversation our Republican colleagues want to have. Since the day he took office, Donald Trump has trampled on the rule of law that forms the very foundation of our democracy, using the power of the presidency to demand vengeance and unquestioned loyalty. He's undertaken politically motivated legal actions against his perceived enemies. If you want to talk about lawfare, that's lawfare right there. Our founders designed a democratic republic built on the rule of law, not the rule of a king. As this administration tests that fundamental principle, it's counting on our Republican colleagues to be too weak and cowardly to stand up to it. Thus far, that's true. But we took an oath to preserve and protect the Constitution. That's our duty as members of Congress, and that's what my Democratic colleagues and I plan to do. I yield back.
I now recognize the chairman of the full committee, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Lawfare is real. It's as real as it can be. November 15th, 2022, President Trump announces he's running for office. 3 days later, Attorney General Garland names Jack Smith as special prosecutor. Now, I understand that's federal and we're focused on state and local prosecutors here, but it's lawfare nonetheless. A few months after President Trump announced he's running for office, Alvin Bragg brings a case against President Trump. A case that his predecessor said wasn't there, a case that the Fed, the Southern District of New York, everyone said wasn't there, but Alvin Bragg brings it because President Trump is now running for the highest office in the land. And then a few months after that, Fani Willis brings her ridiculous case against President Trump and other federal officials, all designed to make it so President Trump wouldn't win the election. And of course, all that was preceded by the whole Russia collusion baloney. Complete baloney, where the FBI, think about this, the FBI went to the secret court. They took information from the Clinton campaign that had first been sent to the Perkins Coie law firm, they then hired Fusion GPS, who then hired a foreigner who put together a bunch of lies in a dossier. They take it to the court, and they use that as a reason to go spy on President Trump's campaign. So lawfare is as real as it gets, and we have a bill introduced by our colleague, Mr. Fry, that seeks to address part of this. It says if you're a federal official and some crazy local prosecutor comes after you, you can move that case to federal court. Go figure. That makes so much sense. That's all this bill does. So I appreciate the chairman having this hearing. I appreciate our good witnesses who are here to talk about what we've witnessed in this great country where it's supposed to be equal treatment under the law. You're not supposed to use the law to target your political opponents. We have a piece of legislation that makes good common sense that we hope to pass tomorrow in the full committee, but today we're going to hear about it. And so with that, again, I appreciate our witnesses and I appreciate the chairman of this important committee having this hearing, and I yield back.
I thank the chairman for his opening statement. I now recognize the ranking member, Mr. Raskin, for his.
Thank you, Mr. Chairman, and welcome to all of our witnesses. The majority Republicans call it lawfare when Donald Trump is held to the rule of law and given every right of due process. We call it lawfare when the Trump administration violates the rule of law and tramples the due process rights of Americans, including prosecutors and FBI agents. Mr. Chairman, we have no kings here, no queens, no titles of nobility, no serfs, no slaves. Our revolution overthrew monarchy and the established church. It made our Constitution supreme over the monarchical and oligarchical political ambitions of any man. The 13th and 14th Amendments abolished slavery and gave equal protection to all, royal status to none. But in our time, Donald Trump's crime spree throughout American society has tested the hard-won principle that we are all equal and that no one is above the law. The Supreme Court that Trump has repeatedly bragged about packing and stacking to destroy Roe versus Wade not only brought the curtain down on the freedom and health security of tens of millions of American women trapped in GOP-controlled anti-choice states, it also made the president absolutely immune from prosecution for crimes he commits under the so-called core functions of his office, presumptively immune from prosecution for other so-called official acts, and subject to prosecution only for private, unofficial acts. After more than 2 centuries, this bracing new taxonomy for licensing presidential criminality was announced by the Roberts Court in a 6-3 decision in U.S. versus Trump. It creates presidential exceptionalism, a plainly dangerous doctrine which overturned a unanimous ruling of the D.C. Circuit Court of Appeals. But even that shocking burst of finger painting on the Constitution isn't enough for Trump and his crowd, who seek now complete immunity and impunity from the laws that bind the rest of us. It's not even enough for them to appoint a nationwide crew of embarrassingly servile judges like Aileen Cannon, who may as well be on the bench in Putin's Russia, as she shows little fidelity to the rule of law, but fastidious devotion to the whims of her dear leader. Now they want to pass something called the Pepper Act, to let Trump and his accomplices get their political corruption and election fixing cases removed from any state court in the land and put in front of far more submissive and pliant Trump appointees in federal court. Donald Trump tried this move in one of his criminal cases, the one in New York City, where he was found guilty of 34 felony criminal counts of falsifying business records to cover up hush money payments he had paid to a mistress before the 2016 election. There, his judge rejected his request to move everything to federal court, saying Trump had failed to meet both the current statutory and constitutional requirements for doing that. As Judge Hellerstein observed in his ruling, the evidence overwhelmingly suggests that the matter was a purely personal item of the president, a cover-up of an embarrassing event. Hush money paid to an adult film star is not related to a president's official acts. It does not reflect in any way the color of the president's official duties. Removal to federal court is reserved for cases where there is an actual federal defense. Let's say the president was tried in Florida state court for assaulting a citizen, but his defense was that the alleged victim was a soldier, and he was just administering fair punishment as commander-in-chief of the army in a time of actual conflict. In that hypothetical case, it would be removed so the federal judiciary could handle the federal question defense. There was plainly no federal question defense in Trump's hush money record falsification scheme. But now, scrambling to appease Trump, an incorrigible recidivist lawbreaker who is looking for a way to disappear all of his state court civil and criminal prosecutions, our colleagues proposed to amend the law so that a president or vice president, or even a former president or vice president, can remove a state civil or criminal prosecution to federal court whenever that case is brought, quote, for or relating to any act while in office, even if that act is of a completely private and personal nature, or where the state court's consideration of the claim or charge may interfere with, hinder, burden, or delay the execution of the duties of the president or vice president. This broad, gaping language would in practice mean that no state court in America could ever conduct a criminal trial of Donald Trump or any other president again, even if the alleged conduct, say hypothetically sexual abuse or criminal fraud, has no relationship to any of his official presidential acts. After all, any litigation can obviously hinder or burden the execution of official duty. It would also permit Trump and his associates to remove the state court criminal cases now pending in Georgia related to the Trump conspiracy to overthrow the 2020 presidential election. This bill is designed to trash basic jurisprudential principles, including federalism, that have served us well since the 18th century. The conceit behind it is the pathetic claim that Donald Trump is just profoundly misunderstood and a victim of the judicial process and a target of unfair prosecutions, although no court has ever once found that. Yes, that Donald Trump, he's the victim, according to our colleagues, the billionaire businessman who's been involved in, check this out, more than 4,000 lawsuits, some in which he is sued as a defendant by, for example, frustrated students at Trump University, or ex-mistresses, or golf clubs alleging non-payment, or plumbers, painters, electricians, and small business contractors alleging failure to pay on their contracts. But most of the ones I could find were ones in which he is the plaintiff, deploying his army of lawyers to sue thousands of people and businesses, including casino patrons, real estate partners, business tenants, and media entities. Most recently, he sued ABC and then CBS for $20 billion. But to hear our friends tell it, Donald Trump is just an Eagle Scout who respects women, would never cook the books, and keeps his hands to himself. The Donald Trump I know about is a civilly adjudicated sexual abuser in New York, a convicted criminal felon, and the only twice impeached president in American history who was most recently impeached in this House for inciting an insurrection against the Constitution, the Congress, and his own vice president. The Senate voted 57-43 to convict him, meaning that although Trump narrowly beat the constitutional spread, robust bipartisan majorities voted that he had indeed incited insurrection against our government. Now look, if you want to see real lawfare, if that's something really in your scopes, then open your eyes to the U.S. Attorney's Office here in the District of Columbia. The pro-January 6th insurrectionist turned U.S. Attorney for D.C., Ed Martin, has fired more than a dozen career prosecutors focused on violent crime from his office simply for doing their jobs, and doing their jobs well. He fired them because they had worked on the January 6th cases, which they were assigned to do, prosecuting Proud Boys, Oath Keepers, and other extremists who violently assaulted our police officers, and they were sacked. Just last week, Mr. Martin demoted several other top prosecutors and career supervisors to entry-level positions, again, as retribution for having simply done their jobs in overseeing January 6th prosecutions. That is lawfare. That is a violation of the due process rights as well as the civil service rights of American citizens who did nothing other than obey the law and do their jobs. And this is just the tip of the iceberg when it comes to the administration's attacks on the rule of law. In its first month, from the corrupt quid pro quo in New York City with Mayor Adams, which led to the resignation of multiple Department of Justice lawyers, including the U.S. Attorney for the Southern District, who had been a Justice Scalia clerk and a career-long member of the Federalist Society, and she said she couldn't put up with that, and she decided to quit. Her assistant, another conservative lawyer who had clerked on the Supreme Court for Chief Justice Roberts, and he said you would have to be a fool or a coward to go along with that corrupt bargain between Donald Trump and Mayor Adams. They have halted anti-corruption task forces. They've suspended enforcement of the Foreign Corrupt Practices Act. They have suspended anti-kleptocracy and anti-corruption initiatives, and on and on. If you want to look at lawfare, let's look at what's going on right in front of our eyes today, Mr. Chairman. That's what we should be doing instead of going after some imaginary lawfare by state and local prosecutors who did nothing other than their jobs, enforcing the law in their states, and not a single judge or appeals court or even the Supreme Court under Roberts Court spell has said anything about those people doing anything remotely unethical. I yield back to you.
Without objection, all other opening statements will be included in the record. We will now introduce today's witnesses. First, Mr. George Terwilliger. Mr. Twilliger is an attorney with more than 4 decades of experience in both private practice and government service. Before entering private practice, he served for 15 years in the Department of Justice as a prosecutor, United States Attorney for the District of Vermont, Deputy Attorney General, and Acting Attorney General. In private practice, Mr. Terwilliger has represented a multitude of private companies, members of the House and the Senate, cabinet officers, and other executive branch officials. Mr. Daniel Epstein. Mr. Epstein is a vice president at the America First Legal Foundation, a nonprofit public interest law firm. He is also an assistant professor of law at St. Thomas University School of Law, where his research includes constitutional law, American legal history, federal courts and jurisprudence, and civil procedure. Ms. Elizabeth Price Foley. Ms. Foley is of counsel at BakerHostetler, where she practices constitutional appellate law. She also serves as a professor of law at the Florida International University College of Law, where she teaches constitutional law, separation of powers, and civil procedure. And Professor Elizabeth Beski. Ms. Beski is a professor of law and associate dean for scholarship at the American University Washington College of Law. Her research focuses on civil procedure, constitutional law, federal courts, and legal writing. We thank our witnesses for appearing today, and we'll begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect that the witnesses have answered in the affirmative. Thank you, and please be seated. Please know that your written testimony will be entered in the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. I would remind each of you to turn the microphone on before you begin speaking. Mr. Terwilliger, you may begin.
Thank you, Mr. Chairman. And thank you, ranking member and members of the committee, for inviting me to appear here today to discuss lawfare by state authorities. I have 3 suggestions for your consideration to curb state lawfare targeting federal officials and to restore the federal officer removal statute to be as Congress has intended it over many years. First, amend the removal law to expressly cover former federal officials. Second, support the Supremacy Clause with legislation providing an expanded scope of removal to include federal court jurisdiction where there are questions of federal law in removal cases. Third, codify Supremacy Clause immunity of federal officials. A constitutional line is crossed when state officials use state law to control federal activity. In 1819, Chief Justice Marshall laid down the law in McCulloch versus Maryland, ruling that under the Supremacy Clause, quote, the states have no power to impede, burden, or in any manner control the operations of the general government, end quote. Congress, over decades, in a succession of amendments of the federal officer removal statute, expanded the protection of federal officers from state prosecutions. As recently as 2011, Congress expanded removal to cover conduct merely, quote, related to, unquote, a federal official's functions. But courts have pushed back, ruling contrary to that congressional intent. In a 2023 decision, the 11th Circuit Court of Appeals overruled 200 years of practice by taking removal possibility away from all former federal officials and again raising the bar for removal, contrary to Congress's 2011 amendment that lowered it. Two members of that appeal panel urged Congress to amend, recognizing what they called a, quote, nightmare scenario, where allowing, quote, a rogue state's weaponization of the prosecution power could go unchecked and fester, which could, quote, paralyze our Republican Democrat system of government, which depends on having talented and enthusiastic people willing to serve. Congress should amend 1442A to expressly cover former officials, but it needs to do more than that to curb the burgeoning lawfare by states using legal actions to attack the discretionary exercise of executive authority. Georgia DA Fonnie Willis's prosecution of my client, Mark Meadows, is a great example of that lawfare. Congress in 1939 passed a statute which authorized presidential assistant positions and established that their duties by law, quote, shall be as prescribed by the president, end quote. Willis, nonetheless, claims that the Fulton County District Attorney can decide what presidential assistants can and cannot do. Her state prosecution charged with the White House Chief of Staff for setting up and participating with the president in a telephone call to a Georgia official. The case against Mr. Meadows should have been removed and summarily dismissed under the Supremacy Clause. But the federal courts in Georgia, in contravention to congressional intent, misapplied the removal statute, not only ruling out former officials, but raising the bar by adding the absurd requirement that to get a state prosecution removed to federal court, a federal official has to prove that he was authorized to commit the very crime the state alleges in his federal role. And now a federal court in Arizona has followed the 11th Circuit's lead, blocking the path to federal immunity and allowing the Arizona Attorney General to prosecute conduct in the very west wing of the White House, the beating heart of the executive branch. Congress needs to act, reaffirming its intent to ensure that state claims against federal officials doing their jobs get moved to federal courts, and those that are barred by the Supremacy Clause are summarily dismissed. Chief Justice Marshall had it right 200 years ago when he drew that bright line for closing state control of federal activities. The draft legislation here presents common sense steps for Congress to address lawfare where state authority oversteps constitutional bounds. It may be that even more needs to be done, but this bill would be a solid start. Thank you, Mr. Chairman.
Thank you, Mr. Terwilliger. Mr. Epstein, you may begin.
Chairman Roy, Ranking Member Scanlon, and members of the Subcommittee on the Constitution and Limited Government, thank you for inviting me to testify on this important matter. President Trump overcame the most vindictive weaponization of the justice system against an American leader in our nation's history. Partisan operatives sought to destroy President Trump in 2016 when the Clinton campaign branded him as a Russian asset by laundering campaign opposition research to the FBI to spy on the Trump campaign, leading to multiple investigations by Special Counsel Mueller. The Mueller investigation substantiated no criminal activity by President Trump, nor could it. Its jurisdictional authority was based on a lie manufactured by Christopher Steele. But as the American people would witness, the first special counsel investigation was mere child's play. 2 impeachment attempts, 4 criminal indictments, one $400 million civil judgment, one mugshot, 3 states attempting to disqualify him from their ballots, 2 Democratic-nominated presidential opponents, and 2 assassination attempts later, Democrats would finally claim their scalp when they obtained a conviction against President Trump in a New York state court, weeks before the American people overwhelmingly reelected him with a historic landslide mandate. The American people saw through the coordinated hit job on their president that culminated in a conviction by a radically liberal jury pool in front of a judge who donated to Trump's first 2024 election opponent, President Joe Biden, and whose daughter works for a firm that represented both Joe Biden and Kamala Harris's presidential campaigns against President Trump, a party arguing before her father. Despite these clear questions about acting Justice Juan Merchan's ability to appear impartial, the jury unanimously convicted President Trump of concealing a crime that it did not even need to agree on or share publicly. But while the New York jury, despite obvious legal errors and corrupt motivations, did convict President Trump, the voters overwhelmingly acquitted him on Election Day, making it clear that they understood the fix was in. The state of New York lacked jurisdiction over the campaign charges against President Trump. The state of New York did not have jurisdiction to hear a case centered on federal election law. District Attorney Alvin Bragg violated a Supreme Court doctrine known as the primary jurisdiction doctrine, which says that a court should stay or dismiss a claim when it implicates issues within the special competence of a federal administrative agency. Here, that agency was the Federal Election Commission. The New York case against President Trump alleged a violation of the Federal Election Campaign Act of 1971. The FECA violates the vests exclusive jurisdiction over issues of federal elections in the FEC and the Department of Justice. In President Trump's case, the FEC did look at the allegations and then decided they were not worth further investigation. This should have been the end of the matter, but Biden's DOJ did not enforce its exclusive jurisdiction, allowing a politically motivated district attorney to bring his own case built on the alleged violation of FECA. Second, a top official in Biden's Justice Department was dispatched to assist the Manhattan District Attorney's Office's prosecution of President Trump. In coordination with President Biden and his campaign's lawfare strategy, New York District Attorney Alvin Bragg resurrected a hush money zombie case under a legal theory that Bragg's predecessor had previously sent back into the grave out of concerns that felony charges would not hold up in court. Bragg's commitment to getting Trump gained him the support of senior Biden political operatives. One day after Bragg announced his primary campaign against his predecessor, Bragg received a contribution from Sherrod Baines, who would later become deputy assistant to the president in the Biden White House. But Biden's operatives for Bragg did not stop there. In December 2022, New York District Attorney Alvin Bragg reportedly hired Matthew Colangelo to jumpstart his office's investigation of President Trump due to Colangelo's history of taking on Donald Trump and his family's businesses. At the Biden Department of Justice, Colangelo served as a politically appointed acting Associate Attorney General, the 3rd highest ranking official in the Department of Justice. The committee's thorough investigation revealed that Bragg's hush money prosecution was coordinated with Biden, despite the obvious links between Biden's Department of Justice and Bragg's district attorney office. Attorney General Merrick Garland refused during a congressional hearing to commit to turning over communications between his Department of Justice and Bragg's office. And the Department of Justice's follow-up response to the committee denied the existence of such communications. Our work at America First Legal revealed that, in fact, 36 responsive records existed between the Department of Justice and the New York District Attorney's Office. Thank you.
Thank you, Mr. Epstein. Professor Foley, you may begin.
Chairman Roy, Ranking Member Scanlon, members of the subcommittee, first of all, good afternoon, and thank you for the opportunity to testify. Lawfare is something we should all agree is bad, and the definition of lawfare is using the legal system, either through criminal or civil suits, to go after your political opponents. Firing people in the executive branch doesn't fit that definition, so it's not lawfare. Lawfare is something that has torn this country apart. It's deepened our political divide, it's undermined the rule of law, and it's distorted, if not destroyed, America's trust in government, particularly its courts. So the good news, however, is that Congress can do something about it. And I want to talk about the removal amendment, the bill that was just dropped, which I had a draft of a little bit earlier, and I will focus on that. But on the drive over, I thought to myself, you know, what really Congress ought to do, if I had my wish list, is I would ask you to consider reorganizing the federal courts. You have plenary control over lower federal courts under Article 3, Section 1. You could take DDC, the district court in DC, and the DC circuit, and you could fold it into a new 13th circuit. You could wrap it into a circuit with West Virginia, with Tennessee, with Arkansas, and you could help dilute a lot of the bias that's happening today that's fueling a lot of this lawfare. It's not going to solve all problems, but frankly, I think that's a very deep problem that we have with the DC circuit and the DDC that you need to think about finding creative ways to solve. So that's one point. With regard to removal, you can also discourage lawfare by toying with or amending the federal officer removal statute. That's going to be really important because if you make removal more readily available, you discourage lawfare because you allow these cases to be taken into the federal court where you have lifetime tenured judges who will represent the interest of the federal sovereign, and they're more insulated from the political winds than their state counterparts are. And these federal judges will then be responsible for deciding the legal scope of important federal defenses such as immunity. Removal to federal court also allows a federal jury to decide the merits of the charges levied by the state against the federal official. And that's really important because federal jury pools are often geographically larger, and this is going to help reduce or dilute the bias that a state or a locality may have against the federal government, particularly if that hostility towards the federal government is sort of focused in one particular locality, such as Fulton County, Georgia, or Manhattan. Now, if we don't have liberal removal standards, if the current removal statutes are not being liberally construed as the Supreme Court says they should be, then we have a problem, as the Supreme Court identified in Tennessee versus Davis, of having rogue states that are hostile to actions by the federal government. And those rogue states then undermine federal authority through lawfare waged against federal officials. The lawfare that has occurred in Georgia and New York have revealed at least 3 substantive amendments to the removal statute that I think are important. The first one Georgia's already talked about, and that is the need to have removal statute clearly state that it applies to former federal officials such as Mark Meadows. It is remarkable that the 11th Circuit, which denied removal of Mr. Meadows' case, did so because he was a former official, but 2 of the 3 judges on the panel, Judge Rosenbaum and Judge Abudu, the first one is an Obama appointee, the second one is a Biden appointee. 2 of the 3 judges on the panel implored Congress to amend 1442 to include former officials. I think that says everything you need to know, that this is not political, this is for the good of the country. And they even said, they went so far as to say that if you don't do this, it could destroy the entire system of government. They said it is a risk that, quote, keeps them up at night. Okay, those are not light words by Democratic appointees. So at a minimum, I think you need to amend 1442 for that. The other thing I think you need to do is make clear that removal is allowed for the president and the vice president. George already touched on that issue, and I'll stop there and look forward to your questions. Thank you.
Thank you, Professor Foley. Professor Besk, your time may begin.
Thank you. Chairman Jordan, Ranking Member Raskin, Chairman Roy, Ranking Member Scanlon, and members of the subcommittee, it is a great honor and a privilege to be part of your deliberative process, and I thank you for the invitation. My name is Elizabeth Earl Beski, and I'm a professor of law at American University, Washington College of Law, where I teach federal courts, constitutional law, and civil procedure. I went to Princeton University and Columbia Law School, and after law school, I clerked for Patricia Wald and Justice Sandra Day O'Connor, and then I spent some time working as a litigator at Munger, Tolles & Olson. As will be apparent, I come to you today not as a politician, but as a nerdy law professor. My message today is a simple one. You can add the proposed language to the statute, but it may not have the immediate, broad, and sweeping effect you intend. In fact, in many instances, it may not do very much. Congress, as my colleague just noted, has extensive power to confer jurisdiction on the lower federal courts. Indeed, the framers conferred on Congress the authority to decide whether lower federal courts exist in the first place. This vast power was limited, however, by Article 3 of the Constitution. The Supreme Court has made clear that Congress may not expand the jurisdiction of the lower federal courts beyond the bounds established by the Constitution. In this area, the Constitution requires that all cases have a federal ingredient. Section 1442, which you're seeking to amend, allows removal by federal officers of civil and criminal actions brought against them in state court for actions they take under color of their office. A unanimous Supreme Court held in Mesa v. California, written by my boss, that the Constitution only permits these kinds of removal where federal officers assert a colorable federal defense. That is the only time there is the requisite federal ingredient. Any other reading, the court made clear, would raise grave constitutional questions. So even though the statute does not include this limitation on its face, we must read it in line with the colorable federal defense requirement. The Mesa Court confirmed that Section 1442 is a pure jurisdictional statute, nothing more. In other words, it provides a pathway to federal courts for a defendant, but does not establish a defendant's entitlement to get there. That has to come from somewhere else. This bill clarifies, as Judge Hellerstein of the Southern District of New York had already concluded, that the statute covers the president and vice president. This bill also takes up 11th Circuit Judge Rosenbaum's call in Georgia v. Meadows to expand coverage to include former federal officers. The 11th Circuit had other things to say on the point of Mr. Meadows' effort to remove. Of course, current and former federal officers cannot remove simply because they hold a particular federal office or because the suit charges conduct under color of that office. Supreme Court's unanimous opinion in Mesa considered and specifically rejected that argument. Perhaps anticipating Mesa's clear instruction, the bill proposes to create a new immunity provision, 1456. This provision confers upon all officers a rebuttable immunity under Article 6, Section 2 of the Constitution from any charges or claims made under authority of state law. Article 6, Section 2 is the Supremacy Clause. The Supremacy Clause does three things. It declares that federal law is the law of the land, even in the states. It establishes federal law is supreme, and it states that if ever there is a conflict between state law and federal law wins. It's basically a choice of law provision. In 2015, in another unanimous Supreme Court decision written by Justice Scalia, the Supreme Court made clear that the Supremacy Clause does nothing else. Stating it plainly, Justice Scalia wrote, "The Supremacy Clause is not the source of any federal rights." In other words, it lacks independent content. So a unanimous Supreme Court has clearly told us we cannot look to the Supremacy Clause to find federal rights. It just tells us what to do when we found them. Plainly then, Section 1456 and the Supremacy Clause themselves cannot provide content for a brand new, very expansive defense. Section 1456 by itself does not solve a Mesa problem. The proposed new official immunity provision certainly does not enact what some have called the Supremacy Clause immunity defense. That term, coined by lower federal courts, has no relation to the Supremacy Clause itself. It confers immunity where officers can demonstrate their actions were necessary to fulfill federal duties. Nor does it enact, quietly, any immunity recognized in Trump v. United States. Thank you for your time.
Well, thank you, Professor Beski.
Thank you, sir.
My apologies. We will now proceed under the 5-minute rule with questions. Chair recognizes the gentleman from California for 5 minutes.
Thank you, Mr. Chairman. This is the simple, awful truth of the Biden administration. For the first time in American history, a presidential administration targeted its chief rival for criminal prosecution, concocted the most flimsy criminal charges, turned the federal law enforcement machinery against it, colluded with the Democratic state law enforcement officials to do the same. This is the historical record. This happened. And when we speak of threats to democracy, what greater threat can there be than one party trying to jail its political opposition? You know, I would frankly advise the ranking member to be very careful in citing the conviction of the president in the kangaroo court of Judge Merchan. A staggering range of legal experts, from Alan Dershowitz on one side to Jonathan Turley on the other, have commented at great length on just how outrageous these proceedings were and how likely they are to be overturned upon competent review. If these professors turn out to be correct, the ranking member and his many acolytes here in this Congress are going to have their words quoted back to them for the rest of their lives. You know, those who've tried to put their political opponents in jail have never fared well before history, and nor have their apologists. Omar Khayyam put it this way. He said, "The moving finger writes, and having writ moves on. Nor all thy piety nor wit can call it back to cancel half a line, nor all thy tears wash out a word of it." So my Democratic colleagues might want to take a step back and consider how history will judge them in the years ahead when passions have cooled and the facts remain. Now, Mr. Terwilliger, in the events leading up to the Civil War, the Confederate States asserted a power of nullification, supremacy over the federal government, that ultimately was resolved at Appomattox Courthouse. But I am unaware of any assertion by the Confederate States that they could, say, seize Abraham Lincoln and try him in their state courts. Is there any precedent in the entire history of our country of what the Biden administration and its partisans in New York and Atlanta attempted to do?
Not that I'm aware of, Mr. McClintock. In fact, privately and to others perhaps in the president's circle, I described the command that Mr. Trump be in Judge Merchan's courtroom when he was already a declared candidate ready to campaign, that he was truly America's first political prisoner. That case needs to be able to be removed from federal court, to federal court rather. I mean, suppose some state authority had decided that Joe Biden was not of sound mind and was a danger to himself or others, including the country, and decided to civilly commit him under state law. Do we think that case ought to have stayed in state court? Of course not. This is a very important step. And if I may just take the opportunity, because I think this is so important, Professor Beski is exactly right about the Mesa decision, which her Justice O'Connor, wrote. And it's why I think that when the committee marks this bill up, you ought to just simply incorporate federal question jurisdiction into the basis for removal, because all of these removal cases involve federal questions, such as what is the scope of the duties of the federal officer. We don't want those decided in state courts.
Professor Foley, you mentioned how dangerous this precedent is to both political parties. What's to stop a partisan Republican prosecutor from going after the next Democratic presidential nominee? You know, the Democrats keep telling us that any day now, President Trump will try to do the same thing to them, even though he had 4 years to do that in his first term and didn't, and hasn't, of course, in the second so far. But if we simply follow the precedent that the Democrats have already set, he certainly could do that. What other measures do we need to take to prevent this from ever happening again? Mr. Terwilliger said that President Trump was the first political prisoner. We'd better make damn sure he's the last. So what can you guide us on?
Couldn't agree more. I mean, this is bad for the country. Yes, based on this precedent, any Republican state attorney general or now President Trump could appoint a special counsel and go after, Biden and anybody in Biden's administration. So the precedent has been set, and it's a bad precedent. What's stopping that from happening? Honestly, we were talking about in the conference room beforehand, it's because Republicans actually believe in the rule of law. We actually believe in norms and preserving them.
By the way, Liberals used to believe that too. I think liberals still do, but the left does not.
They did. I mean, when I worked on the Hill from 1987 to 1992, I worked for a Democratic member of Congress who is now a U.S. Senator, Senator Ron Wyden. And back then, when Ron Wyden was in the House, he was actually kind of moderate and reasonable and liberal, but not progressive. And he had classical liberal values that he adhered to. I think that's been completely lost by the Democratic Party. It's why I am no longer a Democrat, why so many others are no longer Democrats, including, for example, Elon Musk. I know that name is making people go crazy.
We've gone over the time. With that, I will thank the gentleman from California.
Thank you.
And I'll recognize the gentleman from Maryland and the ranking member, Mr. Raskin.
Thank you, Mr. Chairman. First point, the Republicans demanded a special counsel in the Biden case. The Republicans demanded a special counsel to look into Trump because they said that the Attorney General couldn't be trusted. So the special counsel was a demand on the Republican side. In any event, just to get back to the heart of this matter in terms of the law, Professor Beski, you point out that the Supreme Court rendered this unanimous decision in Mesa versus California, establishing that there needs to be a federal question defense in order to remove from state court to federal court. And the burden of your testimony is to say that even if this bill were passed that our colleagues are proposing, it wouldn't alter that in any way because you can't overturn a constitutional ruling with a mere statute. So would there in fact be this intended effect of allowing Donald Trump and all of his associates to be removed from state court prosecutions, even if there's no independent federal question defense?
Sorry, no, and I think it's really important to flag that Mesa considered and specifically rejected the United States argument in that case that federal officers can remove simply because they hold a federal office or simply because the suit charges conduct under color of that office. That was specifically the United States argument, and Justice O'Connor specifically rejected.
I mean, that would be like creating a title of nobility. If you hold a federal office, whether it's elective or appointive, you can never be charged under state law for murder, rape, armed robbery, theft, fraud, whatever it might be. It's just amazing to me that our colleagues would make such an argument that's so breathtakingly anti-federalism that the states are just drained of all sovereignty over the common law crimes that would take place within their state. So if you're right, and I believe that Mr. Terwilliger just conceded that you were, I wonder what you think about his suggestion as a way to repair their bill to simply say that there must be federal question jurisdiction, but that just is tautological. That just restates what the Supreme Court's already found, right?
Well, I think what he's saying is it's enough that the statute says he's operating under color of his office, and that should satisfy Mesa. But
that runs into the supremacy clause fallacy that you pointed out originally.
That's the argument that Mesa rejected. Mesa said that's not enough. That does not satisfy the requisite federal ingredient necessary under Article 3, necessary to satisfy the Constitution. So that argument is a non-starter. They have rejected that unanimously.
So what this really adds up to is some people complaining about the fact that Georgia law enforcement authorities and New York law enforcement authorities operating independently as states within the sovereignty they've got without any actual evidence that Joe Biden or Joe Biden's Department of Justice had anything to do with it, decided to prosecute people for crimes committed under their laws. And they don't like the fact that they weren't able to remove to federal court where they felt that they had a more receptive audience because Donald Trump had appointed a lot of the judges. Right? So what is there actually to do? The Supreme Court has rendered its decision in the matter, right?
It has, and one thing I always teach my civil procedure students is when someone attempts to remove, it's as if you pull a lever. It automatically goes to the federal court, and it's the federal court that makes the call as to whether removal is or is not a good thing. And so Helverson is a federal judge. It is Helverson that made the call as to whether the requisites of the federal removal statute were satisfied.
In the Mark Meadows case, you're saying?
No,
Or in the Mesa
Halverson
case?
is in the Southern District of New York. Halverstein, I'm sorry. He is the person that made the call as to whether it was under color of the office and whether there was a colorable.
So you're saying it was a federal court ruling
That
on the
it wasn't-
question of
Correct.
removability?
Correct.
That would be the same also in Meadows' case and in
Correct.
the Mesa case. All of them go to federal court, and what you have is federal judges saying, with the Supreme Court backing them up, this doesn't belong in federal court.
Correct.
This is a run-of-the-mill state criminal law prosecution.
Correct. It's not under color of office, and there's no colorable federal defense.
And our colleagues want to turn a federal case turn it into a federal case because Donald Trump doesn't like it. And with that, I'll yield back to you, Mr. Chairman.
Now recognize the gentlelady from Wyoming, 5 minutes.
Thank you. Ms. Foley, can you describe for us what lawfare is?
Lawfare is the use of legal processes, either civil or criminal, to go after a political opponent.
And Mr. Epstein, Alvin Bragg's 34-count indictment against President Trump was the first time a former president had been indicted in history. Is that correct?
That's correct.
But the facts of that case had been known for years. Isn't that also true?
Yes, and litigated.
And why did federal prosecutors then choose not to charge President Trump?
Obviously, they didn't think that the evidence substantiated any crimes.
Do we yet know what the underlying crime was that Donald Trump allegedly committed that was the basis for the convictions?
Well, obviously, the underlying New York criminal statute was interpreted broadly, but the supposition is that the president, through this alleged hush money scheme, was engaging in election crimes, and even, of course, the case directly referred to federal election crimes.
But what do you mean supposition? Didn't they have to prove that that's what he had done?
And of course, there was no unanimous jury determination on that. And in fact, there was, of course, no proof. The argument was there must have been some conspiracy with the Trump organization and others.
So they didn't prove the underlying crime. They just convicted him of something in state law. Is that correct?
Yeah, and I would also note that that based off an executive action in New York, there was a stay of these types of indictments during COVID, and there was, of course, a very aggressive reinterpretation of a stay designed to protect criminal defendants in order to go after the president.
Have you ever seen anything like that New York case in your entire years of practice?
No, never.
Were you shocked at what happened in that court?
I was, as were many in the legal academy and many practitioners.
You know, I sit here and I listen to all of the caterwauling on the other side about Elon Musk. I don't know what he has to do with anything today. I listen to all of the accusations about Russia. Boy, I wish we could retire that word someday. That has nothing to do with what we're talking about. I listen to all of these, this nonsense that is being spewed out there. And what I can't understand is why anyone wants to undermine our criminal or civil justice system in the manner that has been done over the last couple of years with lawfare, whether you're a Republican or a Democrat. Can you understand that, Ms. Foley?
No, absolutely not. Like I said, if they can do it, if one side can do it, the other side can do it too.
Isn't that kind of what happens in our political system?
Yeah, because it's politics.
It's politics,
Right,
that's
but
right.
politics and law should be different.
Don't you think that most of the American people understand what happened in these cases? Does anybody really think that anybody was confused or that we couldn't figure this out or we didn't even know exactly what was happening with these cases in New York and the Fani Willis cases? We all knew what was happening, right? It was to stop him from running for president. Pretty simple to figure out, isn't it? Isn't that a classic example of lawfare? Is that what we want our justice system to turn into? Again, whether you're a Republican or Democrat, is that what our Constitution is here for? Mr. Terwilliger, do you think that that's a good use of our criminal justice system?
No, ma'am.
Wow. We have focused a lot on how politically motivated the state and local officials can have been when they target our federal officials, but we also need to consider the Biden DOJ's role in all of this that happened. For example, Mr. Epstein, what agency has Congress charged with adjudicating and enforcing federal campaign finance violations?
That's the Federal Election Commission.
All right, and from a congressional perspective, why should every member of this committee care about the proper enforcement and interpretation of a law Congress drafted? Isn't that our role?
Absolutely, they should.
In Mr. Bragg's prosecution, did the Biden DOJ enforce its exclusive jurisdiction?
No. In fact, we know that public integrity section at the Department of Justice has historically prosecuted election crimes. And yet here, they ceded authority to a state prosecutor.
So they allowed a state court to prosecute a former president in a case that the court had no jurisdiction. Is that fair?
Yeah, and it's, Miss Congresswoman, it's even worse because we have a tradition of federal agencies, even if you want to say that federal agencies have expertise in these questions, we certainly know that state courts don't have expertise in kind of federal questions relating to elections.
They wouldn't have developed it because they don't have jurisdiction.
Exactly, and that's the meaning of jurisdiction.
And then when you bring in Mr. Colangelo and his involvement with this, we know that the Biden administration was knee-deep in the prosecution of Mr. Trump in New York, don't we?
Yeah, and in fact, as America First Legal found out, and of course these documents were withheld under privilege protections, but 36 records existed of communications between the District Attorney of New York, that office, and the Attorney General's office. Yet, Attorney General Garland came to this committee and said that there were no communications.
Thank you, Mr. Epstein.
Thank you, and I yield back.
Thank the gentlelady from Wyoming. I'll now recognize the gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Roy. I watched the testimony earlier, and the first part I saw was Jim Jordan incorrectly saying a lot of things about President Trump. Started with saying that this Mueller investigation didn't show anything concerning Trump. There was no connection. That's because Bill Barr redacted it and made his own opinion on the front end of what the case said, what Mueller said. And Mueller's report made it clear that there was Russian involvement. And the first thing that the Russians did was to send some folks up to Trump Tower to talk to Junior and son-in-law and a few other Trumpers and talk about getting something done. And that woman that came up there to meet with him ended up being in the Russian Duma. So the Russians must have thought pretty well of her. She did her job well. The Senate did a study, bipartisan study, on whether there was Russian collusion. And the Senate Intelligence Committee came out and said, yes, there was. That Manafort went over to France or wherever and met with Klimnikov and gave him the polling data, and this is where we need help. And then that ended up getting to Prigozhin in St. Petersburg, and then they started spewing out all the false social media stuff to make blacks think they shouldn't vote and other people get confused about this and that, and trying to help Trump. And that's what they did. The Russians helped Trump get elected in 2016, and the Senate Intelligence Committee said that, and the Mueller Committee said, the Mueller report said that. And then as far as this trial goes, that you say there's not been a president indicted before. There's never been a president that was so easy to indict. The guy has committed more crimes than all the other presidents put together. Michael Cohen got tried and sent to prison because of what he did in this case. But Bill Barr didn't want to try the president on this, who was individual one, basically saying the president did it, but we're sending Michael Cohen to jail and to protecting individual one. That's what they did. He should have been tried in federal court, but Bill Barr wasn't man enough to do it because he was bought. The president paid off Stormy Daniels and whatever she was, Miss August, whatever, and paid them off so that it wouldn't become public and hurt his presidential campaign. And Michael Cohen took the order, said he had to do it. And they did that. So it was a federal election involvement, and it was criminal law. And the jury found him guilty. How many counts did they find him, Professor? How many counts were there that he was found guilty? 34? 34 times. A jury, Americans, citizens, void-hired by both sides, chosen on 34. They all agreed. 34 to nothing. Every single one of them said guilty beyond a reasonable doubt. And y'all are questioning the American jury system and say because they're in a state court, their ruling wasn't proper. You know, you could commit a murder. Hamilton and Burr had their duel and in New Jersey, I guess it was, and there should be a criminal case, and there was. They want to, this whole law is about helping Trump, who's still hung up on this guilty verdict, which he's not going to spend any time on, or even have to pay a fine. There's no need for this law. But Trump wants to get it in federal court because he's got friends there, and like Mr. Raskin mentioned Eileen Cannon and what she did, which was disgusting all around. She ruined the classified briefs, files case, classified information. And he was guilty as hell of that. And she held it and held it and held it until they can't even get the special counsel's report out. And the Supreme Court put the case on January 6th off and off and off so it wouldn't be heard. The Supreme Court is also involved in this. They were wrong to give Trump a free pass. Donald Trump shouldn't make law. He shouldn't be where he is. That's what happens when you elect somebody who is emotionally, morally, and intellectually incapable of performing the job that they're chosen. You give him a pass from Doge and says, you're bad work, you're fired. I'll yield back.
Thank you, gentleman from Tennessee. I find it interesting that we're now concerned about the intellectual capacity of the President of the United States. I'll now recognize the gentleman from North Carolina, Mr. Harris.
Thank you, Mr. Chairman, and I thank all of you on the panel for your time today and for your testimony. Mr. Epstein, on August 8, 2022, the FBI raided Mar-a-Lago, and the American people witnessed an unprecedented attack on the home of a former president by a politicized FBI. Almost a year after the raid on Mar-a-Lago, on June 7, 2023, Stephen D'Antuono, the former assistant director in charge of the Washington field office, sat down with the House Judiciary Committee for a transcribed interview as a part of this committee's oversight of the FBI. In the interview, Mr. D'Antuono described what he viewed as several abnormalities about the way in which that raid was conducted. Mr. Epstein, in a notice of claim filed in the DOJ in 2024, you argued that the FBI's conduct in the raid, where established protocol was violated, constitutes a severe and unacceptable intrusion that is highly offensive to a reasonable person, end quote. Would you explain to us today how the FBI's raid of Mar-a-Lago was inconsistent with standard protocols?
Well, Congressman, precisely as Mr. Antuono testified before this committee, that we have protocols. We let the attorneys know before the raid is going to be conducted. We typically use kind of the local office to be in charge of it, not the Washington field office to be in charge of that. And the protocols here were wholly inconsistent. And I think that's part of the concerns about when political goals inform what otherwise should be doing justice.
And why do you suppose they opted out of such protocols?
You know, I think here the tone was set from the top. I think and I'll just note that on this question of records and what was probable cause to do these investigations, so much of that was based off the views of the National Archives that these were records that were in the proper ownership of the United States. In large part because of America First Legal's work, we recently showed that the former archivist of the United States, David Ferrero, actually said that we should treat President Trump's records as if they were federal records, in violations of the Federal Records Act, allows us to make referrals to the Department of Justice. That was an arbitrary, capricious, illegal determination that led to the ability for the Department of Justice to have probable cause to conduct this raid. And I think that's something that is a direct piece of evidence of politicization of the law.
Thank you, Mr. Epstein. Mr. Terwilliger, your client, Mark Meadows, is being sued by Fulton County, originally by the very partisan district attorney, Fani Willis. Meadows sought to have his court case moved to a federal court, arguing that was more appropriate because he was acting in the official capacity as Trump's White House chief of staff. After his bid was rejected by the Supreme Court, you argued that the risk puts former federal officials such as Meadows, quote, at risk of being left to the wiles of every politically hostile district attorney or state AG in the country. I happen to agree with you that something needs to be done to protect future former officials from being subjected to the type of lawfare that Mr. Meadows is facing. So my question to you, Mr. Terwilliger, does Congress have a responsibility to protect federal officials from lawfare?
Yes, sir, it does, and it has tried repeatedly to do that, and the courts have repeatedly pushed back for whatever reason, including in the Mesa versus California decision. What Mr. Raskin's comments miss is the fact that all federal courts, all inferior federal courts, other than the Supreme Court, are created by this body, by the United States Congress. You establish their jurisdiction. And what I'm suggesting to you very simply to do what you want to get done is that you incorporate standard federal question jurisdiction into the removal statute. So in a case like in Mesa, where the question was whether or not, if I recall correctly, postal employees could speed or not in doing their job, that those questions get decided by federal judges in federal courts. Otherwise, we have an incredible body of confusion of state courts deciding federal questions. But it is important, because of the Mesa decision, to make clear that federal questions belong in federal court. And indeed, over decades, many federal courts have said the very reason for the removal statute is to have federal questions decided in federal court.
Well, thank you, sir. And I look forward to our markup tomorrow, in which this committee will be taking a look at important legislation seeking to address these issues and prevent future lawfare. Thank you, Mr. Chairman.
I thank the gentleman from North Carolina. I'll now recognize the gentlelady from Washington for 5 minutes.
Thank you, Mr. Chairman. President Trump has a long and documented history of attacking the judiciary simply for following the law. He once suggested that a judge who granted class certification in a fraud case against Trump University could not be impartial because the judge was of Mexican descent. He called other judges, quote, crooked, corrupt, and evil. And most recently, he refused to comply with judicial orders, blocking the implementation of his unlawful funding freeze. My colleagues on the other side have unfortunately endorsed this behavior, and now they propose legislation that would further empower President Trump to evade accountability in the courts. Professor Beski, what effect does this kind of behavior towards the judiciary have on the integrity of the court system? Just briefly.
Well, it takes us into dangerous territory. I mean, the whole premise of Article 3 judges is they have life tenure. The framers tried to remove them from the political process. The whole idea was to have a body of judges free from political considerations. And the idea of disobeying a court order, boy, that's a constitutional crisis. I mean,
it is a constitutional crisis.
That's terrifying.
Yes, it is terrifying. In May of 2024, Donald Trump was found guilty of 34 felony charges under New York state law for falsifying business records to conceal hush money payments made to Stormy Daniels. Republicans believe that this prosecution was politically motivated and corrupt, but they seem to forget about the role of a citizen jury, which came to the ultimate unanimous conclusion of Donald Trump's guilt after hearing both defense and prosecution lay out the arguments. Can you just remind us why the Founding Fathers actually adopted the jury system? 1 or 2 sentences, if you can. That's hard.
I know it's tough for a law professor.
I mean, that was kind of the genius of the framers, right? To put front and center ordinary citizens there, kind of to be safeguards against the government. I mean, to protect and be the decision makers, right? Prosecutors might be motivated to get the conviction, but to have the ultimate decision makers be people, ordinary people who are weighing the evidence and coming to decisions. That was kind of their genius.
It is genius, and there are even some checks and balances built into the system to make sure that jury members are impartial. What are one or two of those?
Well, I mean, you have challenges for cause. They're unlimited, typically in every state, and peremptories, though there are some limits on those, but there's voir dire. I mean, that whole... sequestration. Typically, judges are kept from things, or rather, jurors are kept from things that might prejudice them. Judges obviously have the ability to call a mistrial in the event that there's anything.
So there's lots of things built in to make sure that this is a fair process, and there was no evidence of improper bias or behavior by any members of the jury, right, in that criminal case.
No.
And once again, to confirm, did the citizen jury, this genius system that you've described, unanimously conclude that Donald Trump was guilty of 34 felony charges?
With respect to each of 34 charges.
Each one. So I want to turn to this legislative proposal, which seeks to amend federal law to allow presidents to remove cases against them from federal court to state court. Under existing law, removal is only granted in limited cases, and motions have to be made on specific grounds that allow for removal. And one of those grounds is that a federal officer, member of Congress, or judge can remove a case if the case relates to, quote, any act under color of office. And the Supreme Court, as you've mentioned, has interpreted color of office to mean acts in performance of an official duty. The other side's legislation exceeds this requirement by allowing presidents to remove any case to federal court for any act in office, that's a quote from their legislation, regardless of whether it relates to exercising their official powers. Why is it a bad idea to eliminate that, quote, color of office requirement?
Well, I mean, you're certainly expanding the possible pool. Now, again, always qualified by the MESA federal defense, but you're expanding the possible pool of people who can take this bridge to federal court. I mean, I'm a federalism person, and I believe that having two sovereigns in our system, states and the federal government, is a protection against tyranny. I mean, the framers really thought about this, and that protects individual rights, and to take from states their ability to prosecute violations of state law in their own courts is very intrusive, and the more that's allowed, I mean, that's a problem in our system.
Protection against tyranny, that's really what we're talking about here, and I really appreciate your input, and I yield back, Mr. Chairman.
I recognize the gentleman from Texas for 5 minutes.
Mr. Chairman. The past few years, the left has used every weapon, including weaponizing the Department of Justice against President Trump. But of course, they didn't stop at the DOJ. The left used state and local prosecutors to do their biddings as well. Do you remember the so-called hush money case in New York? This is the case that was led by Matthew Colangelo, the former number 3 at the DOJ. That's right. A high-ranking DOJ official left his job to work for a local DA's office. That's pretty ridiculous and does not pass the smell test to anybody that's competent. And of course, there's the so-called RICO case in Georgia, as if this guy was Al Capone. Thanks, Fannie. And then there's Tish James. She ran solely on prosecuting Donald Trump. That isn't her main job to protect New Yorkers. She was clearly distracted. And you cannot tell me that these cases were not politically motivated. And if President Trump were not running for president again, none of this would have happened, period. None of this would have happened. What people have got to understand is that this is really, really good for fundraising for Democrats. But I'm going to say the quiet part out loud here. They want their veneer of legitimacy. You may have forgotten this, but again, they threw everything at President Trump. They impeached him twice. They tried to remove his name from the state presidential ballots. They laser-focused Lady Justice to eliminate the competition. And how do you survive this? Because he is clearly not like the average person. He is a political force of nature. What happened over the course of the past 4 years to President Trump should shock everyone in this country, because one thing he would always say on the campaign trail was this: if he could do it to me, they could do it to you. I'm just standing in their way. This is repulsive behavior that we saw from the left to prevent a man from becoming the president of the free world, and guess what happened? We, the people, saw right through the crap, and we still made him our 47th president. Thank God for the resolve of the American people. Mr. Epstein, I have a question for you, sir. Thank you for your work to expose weaponization against President Trump. You referenced that the Alvin Bragg case was coordinated with Biden. And for those of us at home, can you walk us through this process and kind of how it happened? And can you explain how Biden and his fingerprints were all over this operation?
Yeah, thank you, Congressman. So I wish we could tell you what the documents would reveal. That's still up in litigation. But what we did, America First Legals, we obviously used a FOIA request to Main Justice to look for communications with the New York District Attorney's Office. And the response, consistent with what Attorney General Garland said to this committee, was that there are no responsive records. And so what we did is what any good investigative lawyer does, is you send a similar request to the District Attorney's Office in New York, the Manhattan DA, and you say, give us all communications with the Department of Justice. And while they didn't disclose those records, they said there's 36 responsive records, which suggests that, in fact, there were communications. And it's important for the public to know what was said in those communications.
Thank you very much for answering the question. And I also want the American public to understand something. The reason why the left is still railing on President Trump, even though he won the presidency, we won the Senate, and we were able to keep the majority in the House, is because, quite frankly, they have nowhere else to go because this lawfare fell flat on its face. We cannot allow this to happen again in the future of this country. That's why we've got to understand our history and how this works. We have to understand that we are a constitutional republic, and we must protect the average citizen in this country, ranging from President Trump to the average person that works every day here in America that makes a decent wage to just take care of their family. Everybody must be treated fairly under the law, regardless of what they do or regardless of what they aspire to be. And with that, I yield back the remainder of my time. Thank you, Mr. Chairman.
Thank my friend from Texas. Now recognize the gentlelady from Vermont.
Thank you, Mr. Chair. I want Vermonters to understand the stakes of what's happening right now at the Department of Justice. And I know many Americans feel in this moment that they can't trust government, and I certainly understand why they might feel that way. Democracies have long struggled with rooting out public corruption, and as long as there is public trust, there are those who will betray the trust for their own power, for their own profit. So how do we combat corruption? How do we ensure the responsible use of power? Those are the things that I think about a lot and that my constituents ask me about. One of the ways that we do that is by entrusting that we have independent, ethical prosecutors to uphold the law, no matter who is in office. And I want to acknowledge and thank everyone for being here today. I especially want to acknowledge Mr. Terwilliger, who previously served the people of Vermont and the nation under the Reagan administration in various roles, including U.S. Attorney. So thank you so much for being here. Mr. Twilliger, do you agree that one of the most effective ways to fight corruption is to establish and maintain a group of nonpartisan prosecutors who are dedicated to the rule of law?
I certainly agree with that, ma'am. And if you'll allow me just 30 seconds. When I was the U.S. Attorney in Vermont, I had no idea if my assistants were Republicans or Democrats. They were people who believed in the rule of law and applying the rule of law. And if one of them had ever come in and said, we should go after so-and-so because or on account of, I sadly have to tell you, ma'am.
If I could, just because I only give 5 minutes.
Please, let me just finish, 10 seconds. I sadly have to tell you that culture at the Department of Justice changed completely in the last 10, 15 years.
So the whole idea, so to stay with what you're saying, the whole idea behind the Department of Justice, right, is supposed to be enforcing the law without fear of favor, correct? And that's what the American people want. That's what Vermonters want. I hear that from them all the time. And that's what our Constitution actually demands. So when a U.S. attorney
stands before a judge and say that they are there not to represent the people, but to represent a president, understandably, there are alarm bells that start ringing. So we're 2 months into this administration. So far, we've had a U.S. attorney publicly state that his office is composed of President Trump's lawyers, not lawyers for the people, not lawyers supporting the Constitution, but President Trump's lawyers. We've seen political purges of nonpartisan career civil servants because they did their jobs, including those who were involved in the January 6th prosecutions. And we've seen a shocking quid pro quo involving the indicted mayor of New York. So you said so yourself. It should not be about partisanship within the office. And I applaud you for that. So thank you for being here. I'd like to turn now to Professor Beski. Professor Beski, under the legislation offered by the majority, specifically Section 1456C, the Attorney General could represent a federal official in any case subject to removal under the statute. Is it true that this provision could make the Department of Justice the personal counsel for the president, the vice president, or for federal officials in state criminal or civil cases? Is there a danger there?
There is certainly a danger because typically the norm is that there's a separation there.
Does that terrify you to contemplate that?
It certainly doesn't help me sleep at night.
Okay, all right, I'll take that as in the affirmative. I do think that it goes strongly against what Americans want, what Vermonters want. They want to make sure, without fear or favor, they want to make sure we're doing this in a way that is not corrupt. But there's, in fact, what I think another important key element here, which is how the public perceives those attorneys charged with enforcing the law. So how important, again, to Professor Beski, how important is the public trust in those who enforce anti-corruption laws?
It's extremely important.
Tell me more.
It is, if the public doesn't have trust in our federal justice system, in the justice system, we don't have very much left.
It doesn't hold together, does it?
It doesn't hold together.
It doesn't hold together. If the people don't believe that justice is blind, anti-corruption efforts are doomed to fail. And authoritarians thrive in that environment where there is no public trust. So what my Republican colleagues have done for many years, and in this committee as well, they've attacked prosecutors, they've attacked judges, they've dragged public servants down here for baseless, in my opinion, baseless depositions, sent letters full of baseless accusations, blasted theories, many of them hateful, all over the internet. And what happens then is that Americans become incredibly skeptical, cynical about there is any such thing as a justice system without fear or favor. And I think that should scare all of us. I understand, Mr. Chair, I'm over time. I yield back.
I thank the gentlelady from Vermont. I'm now going to recognize the gentleman from Missouri, Mr. Onder. 5 minutes.
Thank you, Mr. Chairman, and thank you to all the witnesses for being here today. Last June, the Attorney General from my home state of Missouri appeared before this committee, Andrew Bailey, and testified that Missouri removed a prosecutor who filed politically motivated cases while refusing to prosecute violent crimes, even murders. What the St. Louis prosecutor and Alvin Bragg had in common was that their campaigns were funded through the Vera Institute, which receives tens of millions of taxpayer dollars, as well as funding from George Soros, essentially being funded to not prosecute crimes, but to take political actions against political opponents. In the case of Ms. Gardner in St. Louis, the governor of the state of Missouri. It's no secret, of course, that in New York, Alvin Bragg was on a vendetta to prosecute President Trump. Mr. Epstein, I wanted to. The ranking member said that there was, quote, no federal question in Alvin Bragg's case in New York. So I just wanted to run through that briefly. There was the allegation, of course, in the New York case that money was paid in return for a non-disclosure agreement with Ms. Clifford. Is an NDA illegal?
No.
No. And then in the course of making that payment, somehow the allegation was that business records were falsified. And as I understand it, that was a misdemeanor with a 2-year statute of limitations that had expired. Am I correct there?
Yes, Congressman.
Okay, so, but if the business records were falsified in furtherance of another crime, then the statute of limitations wouldn't be expired and it would be a felony, not a misdemeanor. Is that right?
Right.
Okay. So then the question is, what law was violated? And it's my understanding, as stated earlier in your inquiry with Congressman Hageman, it's the FECA of 1971, the Federal Election Law of 1971. But the Congress invested exclusive jurisdiction over that statute with the FEC and the Department of Justice, as I understand it. I think that was your testimony. So the FEC looked at the case, looked at that allegation and decided that it was without merit. And the New York court did not have jurisdiction over that anyway. I mean, can you explain again how the issue of campaign finance was crucial to this case and was indeed a federal question?
Yeah, no, I mean, I think your bewilderment is justified and explained by a longstanding principle in our American jurisprudence that when you have an agency like the FEC that has expertise in federal election campaign contributions or expenditures, and then you have a state trial judge who has no expertise, that our doctrines say that that judge should stay the case, refer it to the expert agency, and allow them to first adjudicate. If they, in this case, look at the facts and determine we are not going to act, then you can potentially proceed with a further criminal prosecution. And I can say that the primary jurisdiction doctrine has been used in state law prosecutions before to stay those cases. And that was not something that this court was willing to do.
So if a politically motivated prosecutor in front of a politically motivated judge in a venue, a jurisdiction where President Trump could not get a fair trial, shoehorned a federal statute over which they had no jurisdiction or expertise in order to bring charges against President Trump on a very obscure crime. It's just absolutely unbelievable. You know, we had the statue of Lady Justice being blind. I think justice was anything but blind in this case. Well, thank you, Mr. Epstein. I yield back.
With that, I'll now recognize the gentlelady from California. 5 minutes.
Thank you, Mr. Chair. So, Mr. Epstein, I have a yes or no question for you. Do you believe in due process?
Yes.
Okay, thank you. And Mr. Terwilliger, another yes or no question for you. Do you believe in the jury system? Yes or no?
I'm not sure what you mean by believe in it. Do I think that it's a good system in our criminal justice system? Yes.
Okay, thank you. And Professor Beski, do you believe that the right to a jury trial is the very foundation of due process? Yes or no?
It is one of the mainstays of our system, both civil and criminal.
Absolutely. And in fact, our founding fathers would agree with you because the right to a jury trial is mentioned 3 times in the Constitution. So it's kind of important. Not free speech, not even the right to guns, but the right to a jury trial to be judged by your peers. And jury trials are, in fact, how we decide conflicts in this country. And in fact, the president is no stranger to this system. He has routinely said, I don't want a judge to decide my case. I want a jury because I want it to be fair. So, Professor Beski, are you familiar with the Russian term arbitrage? Yes or no?
Arbitrage?
Yes. It's okay. You can say no.
I know the English term, I'm not
Yes.
sure the Russian term.
So the Russian term means the opposite of fair. You don't get a trial. You have a case that's decided by a so-called professional judge. There's no due process. There's no jury of peers. And the judges are there to appease the powers who put them there. And so in Russia, that means the billionaires. So legislative reforms to end lawfare by state and local prosecutors is really, let's just say it, it's overburdening the federal government and taking away state sovereignty at a time when Republicans are talking about cutting costs. But this idea significantly adds more waste, money, resources, and confusion to an already weighed down system, because now you want to push lawsuits to the federal courts, when the vast majority of lawsuits involve state interests, state crimes, not federal concerns. So for example, sexual assault, bribery, landlords threatening tenants, where there is little or no federal statutory equivalent. These cases would be outside of federal jurisprudence. So they want to overwhelm a federal system by litigating a state matter in federal court, and then force federal judges to interpret states' laws. Well, federal trial courts are not set up to try state law cases. What state of jury instruction would they give out, state or federal? And Article III judges, important because they have lifetime appointments, supposedly to free them from political affiliations, misgivings, and bias. They have a very specific type of jurisdictional bandwidth, and state cases are not within it. So this is how I see the idea going. The president, any president's cousin, gets into a bar fight, sucker punches a man and knocks out his tooth. So if the bar fight results in a civil suit for money damages, the president could pluck the case and remove it to federal court. So now we want to cherry pick the litigants ad nauseum, maybe only judges with red hats? Because the only reason to do any of this is to be able to put one's finger on the scale of justice and decide the outcome, and that's not justice. What that really is a merger of the executive and judicial branches, and that is not constitutional here in the United States. The judicial branch is supposed to be independent, and without an independent judiciary, there is no longer a system of checks and balances. And how does this even make sense at a time when you're talking about shrinking the federal government? This ineptitude would overwhelm the capacity of the federal judicial system. I don't know how many people know what goes into the managing of a federal courtroom, but a lot of people who are needed to manage a courtroom. And you're going to exacerbate this system by increasing its caseload. I challenge anyone in this room to find a single federal judge who wants more cases in their courtroom. Their dockets are already full. This seems to be a violation of states' rights to handle their own matters. It is a disastrous attempt to manipulate the judicial system, and it is a weaponization of waste, when in fact you will have more cases improperly or selectively prosecuted. So my fellow Congress members, I urge you to get over your feelings from the last 4 years and recommit to the United States Constitution. I urge everyone to turn to your neighbor and say, I don't want my judiciary co-opted. I believe in state sovereignty. I believe in a jury trial of my peers. And I don't want arbitrage here in this country because I do not speak Russian. And with that, I yield back.
Now I recognize the gentleman from Wisconsin for 5 minutes.
Thank you. First of all, I'd like to thank Congressman Roy for having this hearing. We're dealing with very serious matter and a scary matter. I don't know whether people on the other side of the aisle know it, but right now, if I show up at your average Lincoln Day dinner filled with Republicans or a room full of people who are primarily Republican, they think what happened in Georgia and what happened in New York is just a joke. They have zero confidence, for example, in the New York justice system. I don't like the fact that we're there, but I think that is what people think. And I am one of those people who thinks that way. And I think, by the way, it goes beyond the justice system. I think the same way about the IRS. They think the same way about our customs system. They just think today the federal government is something that I would have guessed was from some banana republic growing up. First question, and it can be for any one of you. Do any of you know any situation other than what just happened in this country in which a former chief of state was charged with crimes and at one point appeared to be facing prison time after they were removed from office anywhere in the world?
Venezuela.
Venezuela. Okay, well, we're headed towards Venezuela. Anybody else can think of any time around the world in which?
Well, I mean, your description, sir, of what many people think is the degradation of our system, there are many of examples of it around the world. You have Pakistan, for example, where seems like every other president is either assassinated or prosecuted, and then the judges of the Supreme Court are themselves prosecuted and investigated. It's what I was trying to explain to the gentle lady of Vermont. We used to have a Justice Department where there wasn't fear or favor, where politics didn't play, but those days are long gone.
Right. Kind of scary. I agree with you entirely. General question, I guess we'll go for Mr. Epstein. How does the lawfare impact the broader relationship between state and federal governments, particularly in terms of constitutional authority and separation of powers? And I should also say, how does it affect how the American people view their government? I mean, we know to a certain extent just the fact that Donald Trump won the election, that people, they just felt being prosecuted by a court in New York was completely meaningless. But go ahead.
Yeah, Congressman, I think the American people, who the Constitution was written for them, well understand that federal questions are within the federal sphere and state questions are within the state sphere. And I think the test is if a legal question can be appropriate, if not more appropriate, for a federal court, that's where it belongs, not a state court.
I'll give you three guys a question because you all hang around with lawyers. Do you know anybody among the lawyers you hang around with who considered what happened in New York a serious, something to be taken seriously, something to be taken as other than just a trumped up political persecution to try to prevent Donald Trump from being elected? How do your lawyer friends, when they hear about this case in the paper, what do they think of it? Do they think, oh my goodness, well...
I guess the ones I hang out with wouldn't be expected to extol the virtues of that process, even assuming there were any, sir. But I think your point is the essential one, regardless of what lawyers think. People look at that, and common sense tells you this was a travesty of justice. The gentle lady can talk about the jury system, but if you cannot admit, based on 200 and some odd years of our history, that juries make major mistakes.
We're in a moral free fall in this country, and juries, like apparently prosecutors in New York, just say, I've got power here today, I'm going to harm a politician I don't like. Is that what you were going to say, Mr. Epstein?
Well, what I was going to say is juries are great in theory, but a lot of what a jury does depends upon instructions that come from the judge. And if you have judges who view their role as political, or who believe that the ends justify the means in terms of what prosecutors are pursuing, they're going to give instructions that are limited, that are problematic. And, the federal courts certainly have had numerous examples of where there becomes judicial review of jury instructions that raise substantial issues for defendants' rights. And if you think about the president and the state court system, that remedy wasn't necessarily available to him.
Thank you much. Yeah, we're about where Venezuela would be. Thank you again.
I thank the gentleman from Wisconsin. I'd like to recognize the gentleman from New York for 5 minutes.
And I would just say, as a representative of New York City, and a former prosecutor in New York, I resent and object to the insinuation from my colleagues on the other side of the aisle that a jury of 12 New Yorkers cannot issue a fair and impartial verdict. And I'm sure that if I said a jury in Wisconsin could not issue a fair and impartial verdict because a defendant was a Democrat, you would object too. And you should, because it's baseless. All of these accusations about lawfare that we hear over and over and over again have no evidence to support it. You say the judge in that trial was politically motivated. Why? You say the judge was motivated? Is it because his daughter works for a digital fundraising firm, that all of a sudden that's politically motivated? That the jury, you can't get a fair trial now in New York? Give me a break. Mr. Terwilliger, did you read the search warrant for Mar-a-Lago?
I might have read parts of it. I don't know that I read the whole thing.
Mm-hmm. And you spent 15 years in the Justice Department as a prosecutor. I spent 10. I left 7 years ago. I hear you say that in the last 10 or 15 years, it's been completely politicized. I have no idea what you're talking about. When I was there, I didn't, just like you, I had no idea the political leanings of my colleagues, of the FBI agents I worked with. So I appreciate your accusations. Maybe after my 5 minutes, since I don't have time, I'd love to hear why you think that all of a sudden 15 years ago, the Department of Justice changed. But if you read that search warrant and you were a deputy attorney general and you were asked to review that, would you say that that did not have probable cause?
I would assume, without my having read it, that a magistrate signed it and determined that there was probable cause. But I don't think
that's obvious. I'm asking you.
That's not either here or there.
Well, it is. See, this is why it is, Mr. Terwilliger, because this is the accusations and allegations from my colleagues on the other side of the aisle, that the search of Mar-a-Lago for classified documents after Donald Trump repeatedly and persistently obstructed justice, obstructed an investigation, held on to classified documents, lied about it, told his lawyer to lie about it, that all of a sudden that search warrant is unprecedented and must be lawfare and politically motivated. Wrong. That was, I don't have a question for you right now, Mr. Terwilliger, but I will, because I want to know, and I want to focus on the here and now. I want to focus on the last 6 weeks. You were a deputy attorney general, correct, Mr. Terwilliger?
Yes.
And it was under the George H.W. Bush administration. You spent 15 years. You may be Republican now, or were then. I'm sure it had no impact on the job you did. You're here as a Republican called witness. Let me ask you something. As Deputy Attorney General, did you ever appear yourself in court because no one underneath you would actually appear in court to represent the Department of Justice?
I don't recall having to do that, but I would have if I had to.
Okay, I don't know what that means, but you never did that. Have you ever heard of any Deputy Attorney General doing that? Before the last 3 weeks?
I actually do have some recollection of that, but it's not sufficiently clear for me to be able to give you.
Fair enough.
Probably
maybe
not.
You're right. It was quite remarkable that the acting Deputy Attorney General, Emile Beauvais, had to appear in the Southern District of New York himself as the Deputy Attorney General because 7 prosecutors underneath him resigned rather than defend a plea agreement that he put in writing was not based on the facts, evidence, or the law. Mr. Twilliger, I'm sure you'll agree with me that the only job that the Department of Justice has is to follow the facts, evidence, and the law. Is that right?
I would agree with that, but I'd also tell.
Okay, so
I would also
I gotta
say,
cut off,
sir,
Mr.
that
Twilliger, I didn't ask you another
US
question.
attorneys have a duty
the other
to follow
problem
their
we
orders.
have here is the U.S. Attorney in Washington, D.C. And unfortunately, I don't have enough time to get into him, but to actually say that I am the president's lawyer, I hope you recognize, Mr. Terwilliger, as someone who cares about the Department of Justice, that undermines the entire law enforcement system more than anything that anyone else prior to January of this year has ever done. And I yield back.
Thank you, gentleman from New York. I'd Recognize the ranking member.
Yes, I have a couple of unanimous consent requests. First, I would ask unanimous consent to enter into the record an excerpt from the committee's transcripted interview with Stephen D'Antonio, former Assistant Director of FBI Washington Field Office, on June 7, 2023, in which he explained that the FBI executed a search warrant for classified material at Mar-a-Lago because there was probable cause to believe that Donald Trump did not fully comply with a subpoena to turn over classified documents.
Without objection.
Okay. I also would ask unanimous consent to enter into the record another excerpt from the transcribed interview with Stephen D'Antonio, in which Mr. D'Antonio explained that he would describe the search on Mar-a-Lago not as a raid, but as a lawful search pursuant to warrant.
Without objection. I now recognize...
Mr. Chairman, I have a unanimous consent request.
Briefly.
Sorry, I'd like to introduce a New York Times article dated yesterday entitled U.S. Attorney Rebuffed by Justice Department in Push to Escalate Inquiry into Schumer related to Ed Martin, the acting U.S. Attorney in Washington.
Without objection.
And then one more, I have a letter dated February 12th, 2025, signed by me and 6 other former DOJ lawyers to the Inspector General, Michael Horowitz, asking him to investigate acting Deputy Attorney General Beauvais and acting U.S. Attorney.
Without objection.
Thank you.
I will now recognize the gentleman from Texas, Mr. Gill, for 5 minutes.
Thank you, Mr. Chairman. Lawfare is antithetical to the American experiment. It's explicitly contrary to the rule of law, but yet it seems to have been the Democrats' last-ditch effort to win the 2024 election cycle. In the lead up to the 2024 election, Democrats knew that they couldn't fairly win. They were running a candidate whose cognitive state was in question, that was declining before our very eyes on national TV while they were trying to tell us that he was sharper than ever. Their political strategy reminds me of the line in Orwell's 1984, which was, the party told you to reject the evidence of your eyes and ears. It was their final, most essential command. And that was consistent with the left's messaging. They were trying to tell the American people, for instance, that defunding the police makes our communities safer, that men can get pregnant and should be sharing locker rooms with our daughters, and that flooding our country with millions of cheap serf laborers would be somehow economically beneficial to our working class. But in order to get over this messaging issue, they attempted to, again, flood the country with people that they thought would eventually become Democrat voters, knowing even now that our election system had legitimate vulnerabilities to it. They directed social media companies to censor lawful speech of American citizens and illegally put President Trump behind bars for made-up federal charges in an attempt to prevent him from getting back into the White House. What we witnessed was a grotesque exercise of raw political power by the Democrats against their enemies. And that's why I'm excited about our markup tomorrow. We've got a series of bills that I think are a good first step in helping ensure this lawfare doesn't happen again. But I want to talk about one instance in particular, which was Democrats calling upon corrupt state-level officials to peruse state-level lawfare and punish President Trump and the millions of Americans who supported his campaign. Their one last hope leading up to the election was to concoct a novel legal theory by Manhattan DA Alvin Bragg. Alvin Bragg in the state of New York didn't have jurisdiction to hear this case. They knew that moving forward would violate settled Supreme Court doctrine, but again, this was their last best hope. The state of New York, with Democrat donor Judge Juan Merchan overseeing the case, finally got their wish. They landed a conviction of the president. But the American people knew it was a sham, and now they know the lengths to which the other side of the aisle will go to attack their political opposition. Mr. Epstein, thank you so much for being here. We really appreciate it and appreciate your work to restore law and order in this country. I want to ask you a couple questions. The charges in the case against President Trump in New York largely revolve around the Federal Election Campaign Act. Is that correct?
Yes, Congressman.
But that act grants exclusive jurisdiction over federal election issues to the FEC and the DOJ. Is that correct?
That's correct.
And did the state of New York and DA Bragg have any jurisdiction over those supposed campaign finance violations?
No, and in fact, Congressman, I would point out that President Trump, during his first administration, made disclosures about payments in his financial disclosures, which is clear evidence that that's a kind of federal nexus, and it's wholly within not just the FEC, but the Office of Government Ethics.
And Alvin Bragg was certainly aware he was pursuing a frivolous case here, yet he decided to very aggressively and very publicly move forward with support from the Biden DOJ. What motive do you think, or would you ascribe to Bragg to move forward with such a clearly baseless case?
You know, I can't speculate on what his motives were, but I think enough is spoken by how the American people recently determined who should be the president of the United States. And I think that there is a general view in the public mood of the American public that looking to prosecute political enemies raises serious concerns about not just the law, but what culture do we want in America.
I agree. Thank you, Mr. Epstein. And with that, Mr. Chairman, I yield back.
Mr. Chairman, you see request. This is from Reuters, January 20th. Who has Donald Trump threatened to criminally prosecute as president?
Without objection.
Thank you.
I would now recognize the ranking member for 5 minutes.
I thank the chairman. Mr. Epstein, it backfired, didn't it?
Wait, Mr. Jordan.
Yes, sir.
Who was it? Mr. Gill who went last? And then it's, you want to go next? So the ranking member.
Oh, I'm sorry.
I'm sorry, Mr. Jordan. So now I'll recognize the ranking member, Ms. Scanlon, for 5 minutes.
Thank you very much. You know, sometimes things get a little more complicated around here than they should be. I mean, we're dealing now with a fairly complex statute, basic core constitutional principles, civil and criminal procedure. Gets pretty far in the weeds, but of course there is a really simple way to prevent states from bringing criminal charges against presidents and former presidents. And that is, of course, for presidents and former presidents not to commit prosecutable crimes. And that's been something that's served our country really well, with one notable exception. But since we are here on this bill, Professor Beski, you explained in your testimony that this bill has the potential to expand the federal officer removal statute to encompass purely private lawsuits based on personal conduct rather than official duties. And I know my colleagues across the aisle are very concerned about the importance of federalism, but it seems like this bill threatens to undercut that federalism and the constitutional division of power. Can you talk more about that provision?
Yeah, I'm looking at provision.
I think it's section 2A2 of the bill that would add section 5.
Yes, section 5, which permits removal of any action against the president or vice president where the state court's consideration will hinder, burden, or delay the execution of the duties of the president or vice president. So this applies on its face only to sitting presidents and vice presidents. Now, of course, we have a norm that we don't charge sitting presidents and vice presidents with criminal conduct. There's a Supreme Court opinion that says they are immune from suits for civil conduct that is official. And so not criminal, not civil conduct that's official. The only thing that's left is civil conduct that is personal, private. And so essentially, the way I'm reading this, the only thing left on the table is this proposed bill adds permitting a provision permitting removal of actions against the president or vice president where the state court's consideration may interfere, hinder, burden, or delay private suits. And okay, I mean, the Supreme Court has specifically said private suits, like Clinton v. Jones said, you can totally sue the president during Clinton's term, he asked for temporary immunity, and the Supreme Court said, no, you can sue President Clinton during his term, no temporary immunity granted. And this appears to expand and say, sorry, we're going to allow removal when a court determines that it might interfere.
Okay. And so that would be with respect to a president, a sitting president or vice president. So basically,
private suits.
Simply the act of being president would give them a pass on everything.
Trump University suits, Clinton v. Jones suits. And that's a big, huge expansion.
Sure. There's another provision in here that I found really troubling. It says, it's section D, no court may define or limit the scope of duties of an official of the executive office of the president. So that would mean that no court could decide, that only the president could decide what were the president's official duties. How does that square with our Constitution?
Well, I think what it does is basically read the color of office requirement out of the statute, because how can you decide whether someone's acting within the color of their office if you can't ask, well, what is their office? What does it entail? What's within and without the scope of their duties? Mm-hmm. It seems to be saying you can't look at what their duties entail. And if you can't look at what their duties entail, you sort of can't answer that question. Well, and so if you can't answer it, then it's not really an element.
Well, then, doesn't that really strike at the core idea of checks and balances, the different branches of government acting as checks and balances if the courts are forbidden from determining whether or not something is within the duties of the president?
Well, it certainly removes that question from the court's purview altogether. What it also does is it greatly expands the number of cases that you are wresting from state courts and, in theory, allowing into federal courts. And so for me, it raises some serious federalism issues.
Okay.
And that's problematic.
Feels like it's an ultimate get-out-of-jail-free card, but it looks like my time's expired, so I'll yield back.
I thank the gentlelady from Pennsylvania. I'll now recognize the chairman of the committee, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. It backfired, didn't it, Mr. Epstein?
Yes, sir.
I mean, the gentleman from New York, our colleague on the other side, talked about he'd trust 12 jurors in New York, but the real jury was the 330 million Americans. I mean, we, the people, are the ultimate jury in our great country. And you think about what they did. I love the list you put together, I think on page 1 or 2 here of your testimony, but it was the dossier, false dossier, that they took to a secret court to get a warrant to spy on a presidential campaign. That wasn't enough. The Mueller investigation, they do all the Trump-Russia Mueller investigation, finds no collusion, no coordination, none whatsoever. Then they raid his home, part of the Jack Smith investigation, Alvin Bragg, Fonnie Willis, the other Jack Smith investigation, the 14th Amendment, and the American people saw through it all. Saw through it all because it was lawfare. I mean, the Democrats' argument seems to me today to be, criticizing lawfare is worse than the lawfare itself. It's just not what it is. So tell me this, part of this lawfare and some of the details, who's Matthew Colangelo?
Matthew Colangelo was an acting associate attorney general in the Garland Department of Justice, who then moved to the Manhattan DA's office to work on the Bragg prosecution.
What did he do before he was at the Department of Justice? Where did Matthew Colangelo work prior to that?
I don't recall.
I think it was the New York Attorney General's office, wasn't it?
Makes sense.
Tish James's office. So here's a guy who worked for Tish James, then worked for the Biden-Garland Justice Department, and then Alvin Bragg says, we want him to work for us. And according to media, he came to work for Alvin Bragg for what reason? I think you put it in your testimony.
Yeah, he obviously was motivated by the case against President Trump.
Yeah, to jumpstart their investigation, I think is the term that was used in the press. And we asked for any communications between Alvin Bragg and the Biden Justice Department, and they said, we've looked and we can't find any. But you disagree with that. You disagree with what Mr. Garland told this committee, the House Judiciary Committee. You disagree with that. Tell me why you disagree with that.
Well, it's not just a question of disagreement, it's a question of fact. The New York Manhattan DA's office let America First Legal know that there were 36 responsive records.
So when Merrick Garland told this committee we can't find anything, that wasn't accurate, was it?
I'll let this committee make that inference, but it seems so.
Wasn't accurate based on what Alvin Bragg told the court, right?
Correct.
Well, go figure. So we'd like that information. That's going to be, I think, the next thing we ask the Attorney General Bondi, if we can get access to some of those 36 responsive records that you talked about. Now, Mr. Twilliger, this legislation that we're talking about, where you can take the case to federal court when you got some state local prosecutor coming after a federal official, it's not just for Republicans, is it?
It's certainly not. And in fact, both as to formers and as to the reinstalling the substantive scope, expanded scope that Congress intended going back to at least 2011, I think every former official of the Biden administration would cheer you on.
Yeah, I mean, like it's just as important for if some prosecutor in Arkansas, Oklahoma, some red state decides for whatever reason he's going to, I would assume he'd do it based on the facts and the evidence, but let's say it's maybe a little shaky. Maybe not. Maybe it's a great case. But still, we're saying, okay, to the chief of staff of President Biden, Mr. Zients, if they're coming after you, you can move that to federal court. You don't have to go into some state court in a red state. You can go to federal court. It applies across the board because we want equal treatment under the law in this great country.
So true, Mr. Jordan. And the fact of the matter is that I really would urge, particularly your colleagues on the other side of the aisle on this committee, to go back and look at what those two Democrat-appointed presidential judges said in the 11th Circuit case. They recognized just how perniciously dangerous it is. What is a chief of staff supposed to do when the president says, I want you to set up a phone call, I need to talk to so-and-so. Oh, wait a minute. Am I going to get in trouble with Fonnie Willis because I do this?
Yeah.
It's absurd.
No, it's absurd. That's absurd. And just the overall attack on executive privilege, for goodness sake. And this goes clear back to George Washington, something we have honored. And the people most close to the president are the White House counsel and his chief of staff, and they've always had that privilege there until now. In their effort to get President Trump, they said, we're going to violate something that's been around since Washington, and they did this. And what we're saying is, let's at least fix it so you can go to federal court, fix part of it, so you can go to a jury that's different than some local prosecution, some jury at a local level.
Yes, sir. These are quintessential federal questions that have to be brought into federal court.
I thank the chairman and our witnesses for, I'm sorry, Professor Foley, I didn't get to you. I usually like to try to get a question to all of our witnesses in these type of hearings. But with that, I will yield back to the chair.
I thank the chairman of the full committee, Mr. Jordan. I will now recognize myself for 5 minutes for questions. One thing that was raised earlier was a little bit about how, 15 years ago, the DOJ may have gotten a little bit politicized. I think, Mr. Twilliger, you were referencing that. I served in the Department of Justice about 15 years ago, right on the number, when I was a special assistant United States attorney. And one thing that I would note, Jack Smith has been at the center of a lot of these issues and debates in terms of lawfare. Obviously, that's in the federal context. When he entered his role as special counsel, Smith had already had a pattern of targeting Republican politicians. For example, in 2013, when he served as the head of DOJ's public integrity section, Jack Smith encouraged his subordinates to contact IRS official Lois Lerner to discuss how the federal government could bring charges against conservative nonprofit organizations. Was that a depoliticized Department of Justice, Mr. Twilliger?
No, sir, and you've hit right on it. When you just use your common sense to look at what's happened. When you see some of the former prosecutors that were involved in some of these cases showing up as commentators on MSNBC, spouting political rhetoric, you don't have to be a genius to figure out what happened at the department.
It's not the only example, right? We can go down Lois Lerner. We can go down a whole bunch of different possibilities. How about Eric Holder himself with Fast and Furious? It wasn't like the Department of Justice was, looking to go dive deeply into what was going on with respect to specifically what Eric Holder did.
I love that example, Mr. Roy, because can you imagine if Pam Bondi stood up today and described herself as Donald Trump's wingman, as Eric Holder described himself for President Obama?
Well, you can see why I was only a special assistant U.S. attorney for a couple of years during the Holder era and decided to move on and work for Governor Perry down in Austin. Let me tell you something. Let me ask you this question. You cited the two members of the 11th Circuit panel, right? And they concurred in the result, but they raised this issue. Is that right?
That's correct.
And the issue they raised, I'm quoting, is, quote, in short, Foreclosing removal when states prosecute former federal officers simply for performing their official duties can allow a rogue state's weaponization of the prosecution power to go unchecked and fester, end quote. Is that a correct quotation?
Correct. Yes, sir.
You share that concern, do you not?
Absolutely.
Could you just describe a little bit? I mean, we've discussed it at some length here, but as we take up this legislation, at the heart of it lies the question that was going on here in the exchange between, I think, the ranking member and Professor Beski and some others about the job and the nature of the job. And so if you're in the case of your client, the chief of staff to the President of the United States, the President of the United States asks you to set up a call, and there is the inherent blend between official and political in what we do, right? And so something is, something we seem as official, you're the chief of staff, you're working through it, and then there's some political questions that come up. So how is it that we can proceed if we don't have clarity with respect to the actual job, with respect to how you were describing that? Could you expand on that a little bit?
Well, I would submit to you, Mr. Roy, that there is absolute clarity in terms of that job. In 1939, Congress passed a statute and said, okay, we're authorizing assistants to the president. Never existed before. Before that, they had always been borrowed from agencies and brought into the White House. Presidential assistants were authorized by Congress, and Congress said their duties shall, quote, be as prescribed by the president. So when the president asks you to make a phone call, you're acting within the scope of your office.
Do you think it would be good for the country were it to be true that, for example, some, pretty aggressive district attorneys in South Texas, or maybe in working coordination with the Attorney General of Texas, decided to say, you know what, we think that the actions of, maybe it was DH Secretary Mayorkas, maybe it was the Attorney General, maybe their actions in leaving the borders wide open to endanger Texans was actually in violation of law. Maybe they should be prosecuted under Texas law because of what they did to the people of the state of Texas, the people in my district who are no longer alive, the people who have suffered the $11 billion we've had to spend in Texas. Do you think it's a good direction for us to go to have it such that state DAs and state attorneys general can then go after officials in their carrying out their official capacity and the ranges around that official capacity? Do you think that's a good thing or a bad thing? And do you think it's important for us to clarify that law?
It's a terrible thing to go in that direction, but that's the direction it's going. And it is inevitable that the worm will turn and there will be Democrat officials of political appointees who will be subject of just the kind of action you describe. This is a place for Congress to assert itself and say, just as the title of this statute says, we want to try to end this kind of lawfare. We may not be able to do it completely. We may not be able to do it perfectly, but it's a very, very important step.
Thank you, Mr. Twilliger, and thank you to the witnesses. I think the chairman of the committee seeks recognition.
If I could, if the chair would indulge, I have one other question.
I would be happy to
give an extra question to the ranking member.
One question. I'd be happy to give you another question if you'd like it. Yes, sir.
I just wanted to underscore a subject we got in right at the end of my 5 minutes with Mr. Twilliger. Mr. Twilliger, why do we have executive privilege?
It's an excellent question, because the president needs the most candid possible advice that he can get, and his aides have to know that if they say, no, Mr. President, that's a really dumb idea, that communication is going to be privileged and protected.
Who ultimately benefits from executive privilege, though? Who's the
people.
We the people, exactly. It doesn't exist to protect the president or his staff. It exists for us, for the American people, we the people. That's why you want candid communications to take place between the top officials in the West Wing so they can make decisions that benefit we the people. And the left has said, we want Donald Trump so bad, we're willing to forego that, hurt the people so we can get President Trump. And thank the good Lord, it didn't work. I yield back.
I'll recognize the ranking member for the gentleman used about a minute and for a question that's along those lines.
Oh, I have to ask a question, not just make a screed? Okay.
You can use your minute as you see fit as the ranking member.
Can we just bring this back to maybe why we're supposed to be here? We're looking at this statute, Professor Beski. Why did the Supreme Court in Mesa say that federal officers have to have a colorable federal offense, and what would this statute do to it?
That's because of Article 3. Article 3, we live in a system of enumerated powers per the Constitution. Just like Congress has a list of things it can do under Article 1, so too, there's a list of things that courts can do. And that's Article 3. And you can't, even though you have power to confer on lower federal courts what they get to do and whether they exist, you are bound by Article 3. And they have to have a federal ingredient. And that federal ingredient is, as Mesa said, that federal ingredient is the colorable federal defense. And Mesa said, here's what it's not. It's not just you have a federal job and this is one of your federal job's duties. Mesa rejected that.
So it's pretty well established, and so this attempt would expand federal jurisdiction beyond Article 3 boundaries, and that's why we suggest everyone should oppose it. I yield back.
I thank the gentlelady. I think for her indulgence, try to do to recognize you equally. I appreciate the witnesses. This concludes today's hearing. We thank the witnesses for appearing before the subcommittee. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, the hearing is adjourned.